Hello everyone, welcome back. I'm Owais Hasan, Assistant Professor of Law at National Law University of Odisha. In today's video, we would be discussing about law relating to the dissolution of marriages. In our earlier video, we have discussed about marriage and the law relating to marriage as per Muslim law, Hindu law, and a Special Marriage Act, in which we have discussed about the nature of marriage as per Hindu, Muslim, and a Special Marriage Act, along with discussing essential and procedure thereof. In this video, we would be focusing on dissolution of marriages as per Muslim law and as per Hindu law. Now, coming to dissolution of marriages, we have to understand what exactly is a dissolution of marriages and what consequences it follows. When two persons get married, they have certain bundle of rights and duties towards each other. These rights and duties include conjugal rights towards each other and other rights like right of maintenance, etc. But once the dissolution of a marriage happens, it leads to breakdown of all these mutual rights and responsibility. Although these rights and responsibility are not completely vanished, there are certain rights which continues even after divorce. For example, right to claim maintenance by a divorced wife, or in case the parties have a child, the right to custody of the child or the child visitation, as the case may be. The relationship created by marriage can be broken, but a relationship which is created by blood cannot be broken. So husband and wife can no more be a husband and wife after dissolution of a marriage, but they will still be father or the mother of the child which they had together. So these are the things which continues. Although with dissolution of a marriage, mutual rights and liabilities towards each other get cancelled. Now, to understand marriage and to understand marriage in the context of Hindu and Muslim law, there are certain theories which we must consider. These theories will help you understand and appreciate the nature of marriages as per Muslim and Hindu law and how they look to divorce. There are four broad categories of theories, or the four broad main category of theories. These are, number 8, theory of indissolubility of marriage. Now, according to the first theory, it says that the marriage cannot be broken down. For example, in the conventional understanding of a Hindu law, the marriage was considered as a sacrament, a union of blood with blood and bone with bone, which continues for the rest of the life of the parties. So this theory says that the divorce is not possible, since the marriage cannot be dissolved and it is an eternal union created by God. Since it has been created by God, no man can put it apart. This theory is now no more relevant because most of the personal law and the secular laws in India and across the world acknowledge the scope of divorce. And one cannot be doomed forever into a relationship which has turned to be a bad relationship for both the party. So this theory is no more relevant, the theory number A. The theory number B is the fault-based theory. The fault-based theory says the divorce can be granted, but it can only be granted in case one of the parties to a marriage has committed a fault. For example, adultery is a fault, cruelty is a fault, venereal diseases is a fault, desertion is a fault. So fault-based theory requires that one of the party must be at fault, or it requires that the party is at some wrongdoing. This is an indispensable requirement for a fault-based theory. Coming to the third, or the C theory, theory number 3, it is will theory or no fault theory. According to a will theory, a person can take dissolution of a marriage irrespective of the fact that there is a fault or there is no fault. The mere fact that you're not comfortable into a relationship is a ground enough for a divorce. And you don't have to prove conventional grounds, like you don't have to showcase conventional ground that the party was committing a cruelty or the party committed adultery or any other fault. So mere fact that two parties are not being able to gel up together and they are not in a happy relationship is a ground enough for a divorce. Coming to the last theory, the fourth theory, is a mutual consent theory. What mutual consent theory says, the two parties may together decide whether they want to live into a marriage or they don't want to live into a marriage. In mutual consent also, you don't have to showcase fault. The mere fact that both the parties agree to it is a ground enough for a divorce. You must have to understand the difference between will theory and mutual consent theory. In mutual consent theory, both the parties must agree. And mutual consent theory will not work if either one of the party is not going for a divorce or is not agreeing to a divorce. Unlike will theory, in which even one of the party who is not comfortable with the marriage may go ahead for a divorce. But that's the main line of difference between will theory and mutual consent theory. In will theory, it can be unilaterally done. Any party can unilaterally break the marriage. But in mutual consent theory, the consent of both the parties is an indispensable requirement. Coming to divorce under Hindu law, the divorce is provided under Section 13 of Hindu Marriage Act 1955. And Section 13 is conventionally based on the idea of fault-based theory, which means to get a divorce under Section 13, you have to prove that one of the parties to a marriage has committed a fault. There are 9 plus 4 grounds provided under Section 13 on which divorce can be claimed by either one of the parties. The first 9 grounds are common for both wife and the husband, but there are 4 additional grounds provided solely to a wife. We'll discuss first 9 ground, which is available to both wife and the husband. The first ground is adultery. As you know, adultery is an act, is no more a criminal act, but is an act which is committed by one of the party, whereby he or she voluntarily had a sexual relationship outside the marriage. The fact of adultery entitles the other spouse to claim for a divorce. Although now, after Joseph Shine versus Union of India, adultery is no more a crime, but it is still a ground for divorce as per Section 13. And one party can claim divorce on the ground that the other party has committed adultery. The second ground for divorce is cruelty, which could be both mental and physical. The third is desertion. Desertion, as per Hindu Marriage Act, means desertion for not less than 2 years. What does desertion mean? It means when the one party leaves the company of the other party without any intention to return, and he continues deserting the other party for at least a period of 2 years. Coming to the fourth ground is the conversion. If either one of the party to a marriage converts to another religion, for example, a Hindu husband converts to Christianity or Islam, that will entitle the wife to claim a divorce. So conversion is a ground for divorce. Fifth is incurable insanity or mental disorder. Any kind of insanity which is incurable in nature or mental disorder which is incurable in nature is also a ground for divorce. Sixth is venereal diseases in communicable form. Any kind of venereal diseases which can be communicated to one person to another is also a ground for a divorce. Seventh is renouncement of word by entering into a religious order. For example, if someone becomes a sannyasi, the fact that he has become a sannyasi by renouncing the word is a ground enough to claim for a divorce under Section 13. Eighth is presumption regarding death. So if a person has been not heard for a period of 7 years or more, he is presumed to be dead. If he is presumed to be dead, this is a ground for a divorce on which other party can claim a divorce. Ninth and the last common ground is a non-resumption of cohabitation for a period of 1 year after the decree of the court. So if you don't join the company of the other spouse through a marriage, after the decree of the court of the restitution of conjugal right, this is the ground on which the other party can claim a divorce. These are the 9 grounds which are available to both husband and wife to claim for a divorce. For a wife, there are 4 additional grounds which are provided. The first one is a bigamous marriage, which means if the husband marries again without divorce or without the death of the first wife, it is a ground for a divorce. Second is when the husband is guilty of rape, sodomy, and bestiality. Rape, sodomy, and bestiality is a crime under IPC. If the husband is guilty of any of these crimes, it gives a right to a wife to claim for a divorce. Third is regarding maintenance. So if a maintenance decree has been passed against the husband, and because of that decree, the cohabitation has not taken place between the husband and wife for a period of 1 year or upward, this is also a ground for divorce. The fourth and the last additional ground for a wife to claim divorce is an option of puberty. To understand option of puberty, an option of puberty basically entails a child marriage, in which a girl has been married before attaining the age of 15 years. She can repudiate the marriage on attaining majority. So if a child marriage has been done, and it has been done before she attained the age of 15 years, she can repudiate the marriage once she attained the majority. This is called as an option of puberty, which is available under Hindu law. In case of option of puberty, you must also appreciate that provision of Child Marriage Act does not invalidate a child marriage. It provides for penalty to parents, those who are attending marriage, but per se the marriage between the two children would not be void, although they would be voidable at the option of the either party. The same is also reflected in the option of puberty, where a girl who has been married during the childhood can repudiate the marriage on attaining maturity. So these are the 4 additional grounds as per Hindu law, which is available only to a wife. So this was divorce under section 13, which can be availed by both husband and wife, and it is based upon fault theory. There is another method of divorce given to Hindu spouses under section 13B of Hindu Marriage Act, which is also known as divorce by mutual consent. The divorce by mutual consent, as the name suggests, is based upon theory of mutual consent. It requires that both the husband and wife agrees together to break down their marriage. For divorce by mutual consent, under section 13B, there are certain procedure which has been provided. We will discuss this procedure. In the procedure, the step 1, as given in your slide, is called as the step 1 of the joint petition. The step 1 is a joint petition in which both husband and wife together should write a joint petition mentioning the following 3 grounds. These 3 grounds are A, that they have been living separately for 1 year, B, that they have not been able to live together, and C, they have mutually decided to end their marriage. So both husband and wife to a marriage to claim divorce under section 13B must write a joint petition stating that they have not been able to live together for 1 year, they will not be able to live together anymore, and they want to dissolve their marriage. This is the step 1. Next step is the step 2, which is also known as joint motion. Once joint petition is done, the joint motion must be presented by the parties between 6 to 18 months from the date of joint petition. So once you have made a joint petition, you have to wait for 6 months, and once 6 months is over, but before 18 months, you have to file a joint motion. Now this 6-month period which has been given is a cooling off period, which is also called as a cooling off period. Why it is being called as a cooling off period? Because in this period of time, husband and wife can think over the decision whether what they want is the right thing or not, whether divorce which they are going to claim is right for them or not. So this is the purpose of a cooling off period. Then after this cooling off period, they may decide that they want to continue with the divorce, or they may decide to live together. So it is their option to choose what they want. If they choose to go for a divorce, the step 3 is follows, which is called as a divorce. And in that step 3, if the court is satisfied with the avertment made in the petition, it may pass a degree of divorce. So these are the 3 steps: joint petition, joint motion, and then the court proceeding happens. The court tries to evaluate what is given in the joint petition and the joint motion, and on the basis of it, it decides to pass a divorce decree as per the provision of section 13B. So these are the 2 broad categories of divorces or dissolution of a marriage which a party can claim under Hindu Marriage Act.